All right, y'all, we live. So the judge decides to give Trump in his defense another shot. We're gonna go check out some highlights. I'm gonna go when the Bulldog was speaking, and we're gonna go over some of it.
If I heard what Mr. Floyd just said, that if everything President Trump said was assumed true and included in the RICO indictment, and therefore now we're talking about true political speech, not alleged false, he could still be prosecuted for the violation of RICO.
For the overt acts as alleged. Let's say even the overt acts ran afoul of the First Amendment. He's saying that wouldn't be fatal to count one.
Because at that point, if
there could be some other thing they prove that's not alleged as an overt act.
Okay, that may,
as I understand
it, as I understood it as well. But what I'm suggesting is, if all of the overt acts are nothing more than core political speech or expressive conduct, and nothing else is alleged which is not protected by the First Amendment, then you have an insufficient basis for which he has been indicted, because he's being indicted for First Amendment speech and not for unprotected speech. And therefore, the statement that was made about if it were true, we could still use it as an overt act, suggests that they could prosecute true speech, which is what we're trying to get to here. It's the nature of the speech, the political speech, the heightened value of such, which gets this situation different than others, and the fact that it comes from then President of the United States. Going back to what was said in addition by the state, what the state claims is criminal here is lying to the government. That's what it said. That's the exact reason why in several of the Supreme Court cases, it's been found to be protected speech because it deals with the government, and falsity in sense of communication with or to the government is best dealt with through true speech, not through prosecutions, because prosecutions chill speech. And when it comes to political core speech, what you don't want is chilled. Fortunately, I have a co-counsel that's able to pull things up and help me inform the court until the computer shuts down. And looking at what Haley says, just to give you an idea of how the Georgia court, the Supreme Court, might look at this. There's a quote from Haley, and it says, "While there is no constitutional value in false statements of fact, such erroneous statements are nevertheless inevitable in free debate, and punishment of error runs the risk of inducing a cautious and restrictive exercise of the constitutionally guaranteed freedoms of speech and press. Accordingly, the First Amendment requires that we protect some falsehood in order to protect speech that matters." And I think that's what we're talking about here. To end this, and again, we're focusing on President Trump's conduct at the time that he, in fact, is the head of the executive branch. There is references to this in Brown v. Hartledge, and I cited that earlier. A well-publicized yet bogus complaint on election eve raises the concerns that you may have some impact that would affect an election. But the preferred First Amendment remedy of more speech, not enforced silence, has special force. Underlying our dependence upon more speech is the presupposition the right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. To many, this is and always will be folly, but we have staked upon it all. And for speech concerning public affairs is more than self-expression, it is the essence of self-government. And that comes from Garrison v. Louisiana, which is cited also in Alvarez. Bottom line here is this: but for protected First Amendment speech, President Trump would not be charged in RICO or the other counts. Take out the protected speech, and you don't have an underlying basis for which to charge him. And since that violates the Constitution as applied to the charges here and his speech here and his position here, this is ripe for a constitutional challenge. One step further. If it's not ripe now and we get into intent, when does the court determine that? Do you determine that after we have a trial?
I think it would be the directed verdict stage.
Well,
right?
would it? That's a sufficiency of evidence.
With all inferences, in favor of the state.
That's a whole question. I mean, do we go through the whole trial? God forbid there should be a conviction, and then we go back to try and determine as applied? I'm suggesting the reason it's right now and the reason why we don't even get to a trial is because it's unconstitutional to force an accused, be it the President of the United States, former president, or anyone else, to stand trial on protected speech. And I think that's what Alvarez and the progeny previous to that and after say.
All right.
Wow.
Thank you, Mr. Stadow. All right. Mr. Gillen, do you need a minute before we dive in, or can we get started?
No, we're ready to go.
Okay. So just teeing this one up. I know there's a good bit of your motion that goes back into a lot of ground I think we covered at the December hearing.
Well,
excuse me,
let me start off with some good news for the court.
I'm happy to hear it.
See the smile already on the court's
All right,
face.
well, consciously
Our general and specific demur, a great deal of that does go into the areas of RICO that the court has not only ruled on, but heard other arguments.
Well, I haven't ruled on it yet, but it was just, we talked about continuity. We talked about
in October, the 17th ruling addresses some of the issues that were addressed. So I'm not going to replow that ground. That the court has heard, aware of the government's position. I know that probably ruined Mr. Floyd's day by not allowing him to get up and go back over his RICO expertise. I'm not going to do that. What I'd like to do though today is to move forward to some areas that I do think needs to be. And the question really, when the court said, do we want to have oral arguments today or not? And then the question was, well, because on the RICO thing, I think I probably could have said, if it was just the RICO component, I would have said, fine, let's just do it on the papers.
You've got a lot of other counts.
There's some other things that I wanted to talk about and have the court focus on as it relates to some of the other aspects of the demurs, special and general demurs, and to focus on that in this way. Number one, I want to talk a little bit about some of the counts impersonating public officers. I want to talk about the forgery, the false statements, briefly, and talk about that, but also to raise this issue with the court. Now, we argued that in our pleadings, but the defendant still filed additional motions on these very issues and did a very, very good job in a lot of his arguments. We know that the court granted the stay for defendant Still because he's of the state legislature, and thus, had that not happened, Mr. Beaver would be here with me talking about these issues. I think that the Still pleading addressed a lot of the issues that were raised in the response by the state, and so with the forgiveness, hopefully, of my dear friend Mr. Beaver, I'm going to mention some of the things that they mentioned, but I would hope on behalf of defendant Still, the court may listen to what I say, but also prior to ruling on these particular issues might afford defendant Still the opportunity to have his own oral argument day so that he could more fully address these issues. And that's and I would appreciate that on his behalf. When we talk, let's get on to it. We're talking about impersonating a public officer charge, and we talk about that. When we talked about that, we talked about whether or not the charge
Definition of public officer, right?
Impersonating a public officer charge, count 8. We say that's subject to dismissal. In that pertinent part, It says on October the 14th, on or about December 2022, unlawfully, falsely held themselves out as the duly elected and qualified presidential electors from the state of Georgia public officers with the intent to mislead. Now, what we did in our pleading is we said, well, that is defective because under the statute 2151, as public officer, there is no reference there to presidential electors as being public officers, and therefore that should carry the day for us. The state's response says, well, not so fast, Mr. Gillen. We've got cases here that talk about situations in which 2151 doesn't carry the day and isn't.
Well, not even cases. I mean, the statute itself.
Right.
I mean, you're pulling that from the ethics statute.
Exactly.
So I'm not really sure why I didn't look at that. I mean, public officers all throughout the code. And it's just kind of one of those hanging kind of question marks, I suppose.
So what the state does, and I can see the court's point. I'm not going to argue that. What I am going to say is that what they say, they cite cases where there are individuals that are impersonating agents, police officers, peace officers, or agents for Metro Atlanta Human Trafficking Task Force. Okay, that falls into that category. Trafficking in the task force or a federal agent. Those are things that the state responds to. I think that in the still motion, it covers some of the concerns the court may have regarding this issue of public officer and why we think that we should prevail on this as well. Again, hoping Mr. Beaver has his day.
Well, do me the favor, actually, I've kind of put the still motions in a box and I haven't opened it yet. So make those arguments for me.
Well, I'm going to,
All right.
but not as articulately, I'm sure, as Tom could do it. But I'll give you the flavor. The flavor of it is that in the still motion, which we adopted as after it was filed, it talks about how other case law in Georgia, when it talks about, first of all, 1610-23 doesn't define public officer. So we start from that so that we've got that out there. Not defining the public officer. Now, but the still pleading does say that the issue of who is and is not a public officer is addressed in other contexts in Georgia law. Usually in the quote merito proceedings where somebody's trying to find out the legitimacy of somebody having or holding a particular office. And in that context, there are cases cited in the still pleading that address this very matter. They cite Brown v. Scott and as a case in which the Brown v. Scott case, whether or not an individual has designation or title given to him by law or exercises functions concerning the public assigned to him by the law, they cite Brown. That the inquiry doesn't really end there. The Georgia Supreme Court has noted the term public officer involves the idea of tenure, duration, fees, emoluments, and powers, as well as that of duty. And so that's McAfee v. Ferguson, and that has to do really with grand jurors. So when someone says, well, is a grand juror a public officer? And the court, breaks down an analysis talking about that, saying not really, because grand jurors may only meet for a few days. They're not essentially, they're not there for some sort of duration or tenure. They don't take the same oath of office as prescribed for public officers, and they lack the element of tenure and duration, which must exist to qualify as a public officer. Well,
so how would that apply again to like a purely fictional task force?
Well, I mean, let's forget the purely fictional task force. It would let's have it that case law from our Supreme Court, how it applies to our case, and how it applies to our case is the presidential electors are not people who have lengthy tenure or duration, which it must exist. Frankly, their job is to meet for one day.
No, I see your framework there, but if the framework is actually in this Whereas the Metro Atlanta human trafficking force, it doesn't even exist.
Well, it doesn't.
We
But
can't
someone is
do this
pretending to
analysis in
be,
your-
someone is pretending to be an agent.
Maybe they're a part-time. I mean, it seems like.
Well, you
know what I
see,
mean?
we might agree to
Yeah.
disagree here, because I think that when someone says, well, here's my badge, I'm an agent of enforcement of the law for, and then names a particular entity that doesn't even exist. They're pretending to be a peace officer. They're pretending to be an agent for the government, which by the very nature of that job would have tenure, would have responsibilities,
Yeah.
would fall into the definition that the Supreme Court has given in Brown v. Scott and McAfee v. Pearson as to what a public officer should be. And so in that context, we have, and same thing actually, it popped up again on the issue of in Morris v. Peters, another case, Supreme Court case dealing with whether or not someone is a public officer. That had to do with a quo warranto against the chairman of the.
So as we see, this was the end of the hearing. There's still hope for Trump, man. Trump is his defense team. I think somebody said he made some billions of dollars a couple days ago, or was it yesterday? So he got money to fight on his defense. And I think if Fani wouldn't have never had that relationship and had that misuse of tax dollars, I think she would have had a shot. But you got to give it to the Trump defense team, and they go in like they getting paid. These are the best of the best, So to think that, because I think it's a war. I think it's Democrat versus Republican. I don't think this is just Fanny's just doing this because somebody's breaking the law. No. I don't think that. I think this is political warfare. This is what's going on. And her job is to make it seem like that. And then another job is to make it seem like it's a racial thing. It's a black versus white thing. And it has nothing. Fani do not need to just sent you a same day. Fani does not need to Fani does not need to make this seem like it is about that. So let me know what y'all think, man. I will catch y'all in the next video. Peace and love.